Welcome to Seminole Sidelines. Happy Wednesday. This is our continuing legal education with the Osceola's legal analyst, good friend Will Fixel, a Tallahassee attorney, and good friend of the Osceola for many decades. With Gary Cutts, publisher of the Osceola, I'm editor Bob Ferranti. Well, we were all at different times in the courtroom on Tuesday, Judge John Cooper hearing the latest arguments in the Florida State ACC case. And I thought the early point of the arguments on Tuesday, gentlemen, was that the ACC doesn't run a business in the state of Florida, that they don't pay taxes, that they don't have a home office. This was a really interesting argument when you have two institutions in the state of Florida. But Will, let's start there again. Thank you for your time and your thoughts on this argument from the ACC's legal team.
Yeah, Bob, and again, thank you for letting me participate today. It's good to see you all again. I think you said it correctly, Bob. The argument that the ACC was making is that that there should be no case in Florida that moves forward, that the case should be dismissed because the ACC has not engaged with the state of Florida to the point that it can be sued in the state of Florida. And those were jurisdictional questions. They're very, preliminary questions in the litigation about whether it can move forward because the ACC has not engaged with the state of Florida to the point where it can be sued in the state. This goes back to the basic ideas of federalism within our country, that you have a federal government and then you have state governments. And the question is it an entity or an individual engages with a particular state? In this instance, the ACC would say we're engaged in the state of North Carolina, but we aren't. We don't have sufficient contacts and engagement with the state of Florida in order to allow someone to sue us in that separate jurisdiction in that state. And from a lawyer's perspective, I certainly understand the ACC's legal team making every argument that they think is available to them that is colorable. But again, from a lawyer's perspective, it appeared to me that the ACC's objective was to slow this process down in Florida, to run the Four Corners offense, to use an ACC term, just to try to create a situation in which they're running as much time as possible because for whatever reason, the ACC appears to think that that's a strategic advantage. The reason I say that is having sat in the courtroom for a good part of the morning yesterday with the two of you, it just didn't resonate with me. The ACC's arguments just did not resonate with me. And I guess, and I think I leaned over to Bob, you and Jerry at some point and said, maybe I'm just a novice, but it seemed to me, I always was with the understanding that when University of North Carolina came down to Tallahassee and played a sporting event and one of the teams won, and you opened up the Osceola the next day, or you went to the website, you'd see the ACC standings change by someone won and someone lost. And that was part of what the endeavor of the ACC was, to play these games and to have a conference in which those games counted. That to me seemed to be just the most basic argument. But the legal teams went into much greater detail about revenue being generated in the state of Florida. I thought Florida State's attorneys had very compelling arguments about the money that the university has spent to have all kinds of recording studios, to allow the ACC network to operate out of Florida State University. And then there were some arguments as well about contracts that the ACC has entered with businesses like Fanatics that operate out of Jacksonville. And so because of all of that, Judge Cooper ruled that the ACC does have sufficient connection with the state of Florida to allow the ACC to be sued in the state of Florida. Again, and I appreciate you and Jerry, because you were troopers yesterday, sitting and listening to all that argument, because it was highly technical. It was frankly not all that interesting. It was very procedural, very technical, and I think at the end of the day, common sense prevailed that if you just walked up to any Florida State fan on the street and asked, does the ACC conduct business in the state of Florida, or a lot of business in the state of Florida, frankly, they would have said yes. And at the end of the day, utilizing a whole host of legal tests, that's in essence what Judge Cooper ruled. And I think it makes a lot of common sense, if nothing else, and I think it will very likely stand up legally, because the ACC does conduct business in the state of Florida through two institutions, Florida State University and the University of Miami.
So, Will, you've had the opportunity to try cases in front of Judge Cooper before, and you know his style of, it's almost like he thinks out loud. And it seems very thorough to me. But I found it somewhat entertaining, some of the paths of logic he took us down, in terms of things such as how high the cheerleaders could throw each other being regulated by the ACC. And, I kind of wondered, where was he going with all that? But at the end of the day, all those probing questions, I thought, led to him verifying what I thought might be his thought coming in, that this is a business, and you can call it whatever you want to call it, but it operates as a business.
Right, and it operates in the state of Florida. And I thought, for the portion of the hearing that I was able to attend, I thought Judge Cooper utilized extreme thoroughness, like you said, and where you and I and a lot of people listening may have been frustrated with the ACC's argument, because it is so preliminary, and it is, I think, so contrary to common sense that the ACC wasn't engaged in business in the state of Florida. I thought Judge Cooper yesterday was extremely thorough and did a very good job of just drilling down and drilling down and drilling down, so that he could put as many of the alleged facts. And again, since we're at the very preliminary stages and we're at a motion to dismiss, and we talked about this on previous episodes, but we're in a position where you look at what the complaint that was filed, you look at all the facts alleged in the complaint, and you assume all those facts to be true, and then you, as a judge, you figure out whether, as alleged, those facts allow and for things like personal jurisdiction. And so I think Judge Cooper was extremely thorough, and I think he did that, Jerry, because he understands that, given the importance of this litigation, and given the power of the legal teams, and the amount of money that is going to be spent on this litigation, that it is very likely to be appealed, and he would like his orders to be upheld, and in the most foolproof way of making sure that his order can be upheld is to have as many facts as he can. And I think that order is foolproof. I mean, I think the odds are that on this very preliminary issue, one of many in this litigation, that Florida State is likely to prevail, that the ACC does engage in business in the state of Florida sufficient to be sued in the state of Florida.
So let's go into what Judge Cooper did rule on Tuesday, and this was in the matter of personal jurisdiction. And like you said, getting a little bit technical, a little bit into the legal weeds. What did he rule on, and what does it maybe mean in the big picture here?
Yeah, I mean, again, I think Judge Cooper referred to it as getting over the first hurdle of the race. And in essence, what he did is he denied the ACC's motion to dismiss the complaint, the second amended complaint in Florida. In other words, the case can continue to move forward. It does not mean that Florida State has won the case. It just means at this preliminary stage that the case can move forward or that, let me say that in the negative, that the case is not denied, that the case isn't kicked out because the ACC has not had sufficient contacts with the state of Florida. Now, there were some other grounds that the ACC also alleged that the case should be dismissed. As I understand it, they ran out of time yesterday, so the parties are going to brief that issue more thoroughly, and then he's going to rule on those issues as well. But on the discrete issue of whether the case must be kicked out or dismissed because the ACC has not engaged in sufficient business contacts with the state of Florida, that issue, Judge Cooper ruled, was not correct. That would not be a basis for dismissal.
Okay, so in the argument of where are we in this track meet, it feels like we're still pretty early. I said to a couple of the writers at one point, because some of us were watching or monitoring a baseball game during a court hearing. Thank goodness for FSU's stat broadcast, but it felt like we were in the second inning of a baseball game, and there's two concurrent baseball games going on, one in Leon County's court and Mecklenburg court. I'll be honest, it feels like we're really, really early in this kind of track meet, to use Judge Cooper's term. What's kind of your feel on it? Does it feel pretty early?
It is very early, and we're 6 months into the litigation. And so, one thing that the listeners need to understand, Osceola readers, is that the wheels of justice turn slowly. And particularly when you have high-powered attorneys on the other side that can come up with creative legal arguments that may not prevail but are colorable, and they can, like I said, run the four corners offense, and that is what it appears to me the ACC is doing in Florida. And the ACC, I'm sure, has strategic reasons why they're doing that, why they want the case to move forward in North Carolina first. We talked about that on previous episodes about how this is a very unique procedural posture for the case. But we are in the I would say we're likely, we're still in the first inning of the case. We're still in the, has the complaint been filed properly, and does it allow for this case to move forward in Florida? That's opening stuff, at very, very beginnings of the litigation. And I hate that it's had to take this long, but you can get into litigation that moves at a glacial pace, and particularly when one of the parties has a strategic objective to make that litigation move at a slow pace. And that, it appears to me, that is what the ACC is attempting to do, is to just make FSU litigate every issue extensively, and to just very slowly march through the case. So I think that's right, Bob. I think we're at the very beginnings of this, and we're trying to get over fully that first hurdle so that we can move forward. One possibility is that there could be an interlocutory appeal. I know there has been one in the North Carolina case that Florida State has filed with respect to sovereign immunity issues. There are these jurisdictional questions because they're so preliminary. Can this entity, the ACC, be sued in Florida? Well, the idea in interlocutory appeals, and what an interlocutory appeal is an appeal that happens before the finality of the case, before a final judgment has been rendered. The idea of interlocutory appeals is that there are certain questions that are so fundamental that it would be inefficient for that question not to be addressed prior to the finality of the case, prior to the case ending. So personal jurisdiction is one of those issues in most cases and under most circumstances. And the reason is because if you as an individual don't even have the ability to be sued in the state of Florida, why are we getting to the finish line before we make that final determination? Because then we will have engaged in a lot of judicial effort that isn't necessary. And so I would frankly anticipate that the ACC will at least attempt to appeal this personal jurisdiction ruling to see if they can continue to slow down this Florida case. And, it is very possible that Florida State's in for a long haul. That probably has to do with the ACC believing that it puts Florida State in a financially disadvantageous position to have to litigate for years in order to reach a resolution of this, and having defended cases, significant cases, that can be a very powerful strategic position to take.
At Aviva Stadium in Dublin, the home of
Hey Seminole fans, Alumni Hall is your ultimate FSU shopping experience and has moved to a new location off Timberlane Road in Tallahassee. Shop FSU gear from Nike, Champion, New Era, Yeti, and more. Alumni Hall has Seminole gear for the entire family, plus accessories and gifts. Spend $150 and you'll earn $10 off your next purchase with their Hall Pass rewards. Stop by their new location on Timberlane Road near REI or shop anytime online at alumnihall.com. Alumni Hall, where Seminole fans shop.
Yeah, so we thought we crossed the first hurdle yesterday, but maybe not so fast, my friend.
Yeah, we could have additional litigation, in particular an appeal regarding this issue. If the ACC can fulfill all the requirements necessary to file an interlocutory appeal, which they may attempt to do. FSU has done that in the North Carolina case, and it would not surprise me to see the ACC, as long as they have a colorable argument for getting that appeal booked to the First District Court of Appeal, trying to do that to slow the matter down even further.
Jerry, is it plausible? This thought crossed my mind the other day in the courtroom too, is that FSU would have to inform the ACC by August 15th if it intends to depart the conference. Again, that letter has not been written. It was discussed last August 1 in that kind of infamous Board of Trustees meeting. Is it possible, again, the legal team might be running out the clock to avoid FSU? When I say the ACC legal team is trying to avoid having Florida State prepare that letter by this August 15th, are they essentially trying to run out the clock and avoid that happening?
Yeah, it's a great question. And you wonder if you could even get another hearing before August.
Right.
I mean, with the way that the court calendars are. I mean,
well, think of it this way. If you're the ACC, and let's just take the rosiest picture you can paint for FSU. Let's say that the grant of rights is invalid, that all of the FSU can just walk out of the ACC at the end of this litigation once everything's been determined in FSU's favor. The longer it takes FSU to get that ruling, the higher the settlement value for the ACC, because that's under the absolute best case scenario for Florida State. And so I to your point, I think the ACC has a vested interest in making FSU take as long as possible to get to FSU's preferred result, assuming, and I think it is a big assumption, that FSU can ever get to that result. In addition, the ACC, it appears, believes, given how they're trying to move the North Carolina case forward and not move the Florida case forward, believes that they have a strategic advantage for having the case move forward in North Carolina. So slowing the case down in Florida gets back to that idea that we've talked about in previous podcasts of the race to the judgment. If they can get a judgment in North Carolina that they think is more favorable, then there's another strategic reason to try to slow down the Florida case. All of this is, complicated because this is particularly complex and complicated litigation, given that there are multiple lawsuits going on. And then, of course, there's the Clemson lawsuit as well in South Carolina. So it's complicated stuff, but it does appear, and just having sat in a portion of that hearing yesterday, it was clear to me that the ACC's objective was to slow the Florida litigation down to a crawl, or make it stop completely, and that was pretty clear to me what they were trying to do. They have good lawyers. I thought their lawyers were making the best arguments they could, but at the end of the day, if you look at the forest from the trees, the ACC conducts business in the state of Florida. And so you have to ask yourself, why would the ACC be fighting that argument? And the answer is, strategically, I believe that the ACC wants to argue everything so they can make things in the Florida case move at a snail's pace.
Well, let's get a little bit out of the legal weeds here for a minute and get to the possibility. Again, I'll emphasize possibility that settlement could be on the table. The legal teams did say yesterday that they had I'll call them productive. I'm not sure what their word exactly was, but they had early discussions on sitting down at the table to hold mediation. This gets complex for a lot of regards, especially in that ESPN contract, where I think the ACC legal team would very much want that wording or certain wording redacted. Of course, the FSU legal team would like to see that document about in full so they can kind of pick apart and see what legal precedent might be there potentially from that Maryland case about 10 years ago. The Maryland case did come up a little bit on Tuesday in the courtroom, but Will, to you first, the prospects of sitting down at mediation. Judge Cooper encourages this in every court case. It seems like he's encouraged this, I think, in all three hearings so far, April, May, and June. You've said the bar to clear mediation is very low, but what could it mean? Could it be productive?
Yeah, so let's just remind the listeners as to what mediation is. Mediation is a voluntary process. You can be ordered to mediation, but at the end of the day, it is a voluntary process in which the parties sit down with a neutral third-party mediator, an attorney who is skilled in attempting to bring parties together to resolve a case voluntarily. There is no judicial decision that occurs at a mediation that is binding on any party. It is simply a voluntary process by which, in Florida, there is an attempt to settle the case outside of the need for final determinations in courtrooms. And so mediation is highly successful. I use it in my practice with regularity. I am fairly skeptical that in this case mediation at this point would be successful, but it might be. Some of the cases that you walk into thinking will never settle, because when the parties sit down at a table together and actually listen to each other and hear the risks of litigating further, sometimes cases do settle, at mediation that are very difficult to settle. The reason I am fairly skeptical at this point that mediation would work is because when you're in most litigation, when you're mediating, you're representing a party, you're thinking, what arguments will persuade the other side to try to reach a resolution, and conversely, what arguments will the other side make to my client that will convince my client there's enough risk to try to put this litigation behind them and reach some sort of settlement. In this case, I think there is very likely a more fundamental issue than even that has to be addressed. And it has to be addressed from the ACC's perspective, and that is, if I'm Florida State's attorneys going into mediation, trying to put together an opening statement that you would have at mediation when everyone's in the room that states the position of why the ACC should strongly consider settlement. The issue I would have if I was FSU as attorneys isn't what argument to make. It's who am I speaking to in that room that is the ACC. Because there are 18 different member institutions for the ACC, each of which have their own perspective on these issues. Beyond that, you have parties that aren't even going to be at the table, like ESPN, who will have a say in whether the case settles, because the lifeblood of the ACC is the ability to have these media contracts that pay them tens of millions or hundreds of millions of dollars, right? So I think there is what makes this case, settlement in this case, in my opinion, so daunting, and I think we're going to try to talk about this on future episodes as well, is that you have 18 member institutions, each of which have their own agendas for what they would want to see in a settlement. So if you're Jim Phillips and you're the ACC, who's the commissioner of the ACC, and you're the ACC, how do you satisfy enough of those interests to, number one, get an agreement approved by the member institutions, which would be the most fundamental thing that has to happen. But two, even more importantly, from Jim Phillips' perspectives, have enough member institutions be happy enough with settlement such that the ACC will continue to exist after settlement, right? And Jerry and Bob, I'd love to hear your thoughts on this, because you know as much as I do about each of the different member institutions' objectives. But that is a daunting task. I mean, that is a very, very difficult position for the ACC to be in. And I would find it very difficult if I was Florida State going into a mediation, trying to both provide an opening statement in that mediation that would be compelling to the ACC to try to have them settle, as well as to provide additional arguments when those negotiations really go on in earnest during the day. The way that functionally works is that parties go into separate rooms, and the mediator goes back and forth between the two rooms to try to negotiate between the parties' positions. What you're trying to do in that, when the mediator is in your room, is to provide that mediator with arguments, additional arguments, to go in the other room to convince the other side to either put more money on the table or to reduce the amount of money that they're seeking in the case. I would find that to be a very, very challenging position for FSU to be in, to know what to argue, to convince the party in the other room, the ACC, to lower their settlement demand to get Florida State out of the ACC, because I don't know that I would be able to know who I'm talking to in that room that would really control the decision-making ability. And I'd be very interested in what y'all have to think about that as well. You know, at the end of the day, of course, you've got Jim Phillips and the ACC's general counsel and people in that room that have clout, but they have people who they're responsible to, and who really matters in that second layer. You know, and your guess is as good as mine on that.
Bob, I think didn't Rush make that comment during the hearing yesterday?
Yeah, I don't think it was a jab as much as it's an honest point that the ACC legal team has to serve potentially 18 bosses. And more than that, if you're looking at, well, it's the president / chancellor plus their board of trustees, plus all the phone calls from all the boosters that may or may not be coming in because they have influence on decision making. But yeah, I mean, Jerry, you've worked for countless presidents and ADs at Florida State. I think you've commented often there is alignment currently at Florida State. There may or may not be alignment at various ACC schools as far as how this decision, you know, how they feel that it might protect their institution moving forward.
Well, first of all, let me correct you. It hasn't been countless presidents and ADs. Not that old.
I don't mean it that way.
It has been 6 or 7, though. And that's exactly right. I think that's the most important thing that I learned in my experience in administration is alignment, and that it changes every time you get a new president or you get a new AD or even a change in the board of trustees. You can have disagreement. And right now, Florida State has beautiful alignment. And I've seen that in other years. I've seen it when it's been good and when it's been bad. But, you know, you're dealing with 18 universities. And, you know, presidents usually only last about 5 years. And so you're constant. It's a continuous process, you know, of probably akin to having babies in diapers. You know, a new president comes in, he changes things, you know, and everybody else has got to rethink that institution until he establishes who he is. And so, yeah, I think it's a very dynamic world that you're trying to effectuate. Well, I would wonder, I'm asking questions because I've never done a mediation or been involved in one. But if you were the legal team, Florida State's legal team, I guess you would, my hunch is you would sort of be doing your homework and research where are the votes, and and there'll be some people, I don't know, I'm just going to say Wake and Duke, who maybe, what might influence them more than anything is not keeping FSU, but how much is the settlement and how much of that they'll get.
If I was FSU, I would have 2 or 3 marker boards in a room with each institution's name written on it. And I would try to figure out what the motivation for each institution is. And as you said, Jerry, Boston College is going to be substantially different from the University of North Carolina. I mean, and to your point, Jerry and Bob, it is a fluid situation. And it's fluid not only because of internal politics of each institution, but, a month ago, 6 weeks ago, we had this settlement on the antitrust lawsuit, where it now looks like each institution of the ACC, each institution that wants to play college athletics is going to be now spending tens of millions of dollars every year if they want to pay players.
I think that's a big dynamic.
And the University of North Carolina, very shortly after that, changed their tune on some things. And at least certain individuals at that institution that have power did. And so, again, that's a very difficult task for FSU. But what I would do is I would try to establish in my mind what each institution would like to see out of a settlement. I would, and that's very hard. The second thing I would try to do is I would, when you get in litigation, there's such a tendency, particularly if you haven't been in a lot of litigation, to this fight attitude, fight to the end attitude. And there's strategic advantage to having the other side know you will take this to the mattresses, right? Take it to the end line. But for mediation purposes, I would try to figure out not what is the maximum pain that we can inflict upon the ACC. I would try to figure out what is the path for the ACC to continue just without Florida State being a member. And then I would look back at those objectives of each institution, and I would try to think of a way that the mediator can convince the ACC that here's a settlement that satisfies enough of the objectives of the member institution and will allow for an ACC, albeit an ACC without Florida State and maybe without Clemson, maybe without the University of North Carolina, but to still exist. Because going into this, even though I have no inside knowledge whatsoever, zero, that Jim Phillips and the ACC will not accept a settlement that they believe will kill the conference. You do not accept that settlement if you're the ACC unless the member institutions just demand that you do it, right? And I think there's enough member institutions that won't allow the conference just to die. And so if I'm FSU, those are the two questions I'm trying to answer. Is what is the individual objective of each of the institutions, and how can I thread the needle to allow the ACC to continue to exist, to allow enough of those member institutions' objectives to be met, to stay in the ACC, and at the same time bring the settlement value of the case down enough to get FSU out of the conference. And that's just a really hard thing to do. I mean, and it may be at the end of the day that in order to get to that point, the member institutions need more information. And the way you get more information is that you allow additional litigation to occur and judicial rulings to happen.
Even to discovery.
Through discovery, maybe to the point where you have one of the cases and there are 3 now: North Carolina, South Carolina, and Florida, to reach a conclusion, which may be years away.
Yeah.
That's why I'm a little skeptical that this can be settled at this point, because the stakes are so high. There are so many cooks in the kitchen for the ACC perspective, and it's just going to be a very difficult case to settle. Not impossible, just very difficult.
Okay, Will Fixel, thank you again for your time. For Jerry Cutts, I'm Bob Ferranti. Just want to remind you all, thank you for subscribing to the Osceola. Thank you for subscribing to our YouTube channel. If you are not a subscriber, now is a really good chance to jump in. Go to theosceola.com, use promo code FSUVisits24. Again, FSUVisits24. Get all of our coverage, all of our message board intel, fish bits, thoughts on recruiting, FSU baseball live threads, legal threads from the courthouse, all that coverage from the Osceola. Again, go to theosceola.com, FSUVisits24 is your code. We appreciate you all watching or listening, and we will be back. There will be more to discuss on this with Will Fixel. Again, Tallahassee attorney, we appreciate his time, and we will see you next time on Seminole Sidelines.